Well, hello, greetings. My name is Mikhail Karayanni, and I'm from the Hebrew University, from the Faculty of Law. And I'm going to be chairing this session titled Multiculturalism, Religion, Gender, and Law. And it's part one. Part two, I gather, would follow. And we have four speakers and a respondent. And as we go along, I will be introducing each of our speakers. Uh, so our first speaker is Lisa Fishbayn Joffe from Brandeis University. And Lisa is the Shlomit Reinhardt's director of the Hadassah Brandeis Institute at Brandeis University. It's a research institute focused on Jewish women's and gender studies. She is also director of the HBI project on gender, culture, religion, and the law. Her research focuses on gender issues at the intersection between secular and religious law. She is an author of a number of books, 3 books actually, among them women rights and religious law. And Lisa's presentation is titled Exit, Voice, and Effective Remedies for Women Disadvantaged by Minority Religious Practices. So Lisa, the floor is yours, virtually, of course.
It's a pleasure to be here and see so many wonderful colleagues. I'm going to talk today about issues of gender and multiculturalism in the context of child custody disputes involving Hasidic exiters. Those are exiters from the community. There have been a series of recent popular memoirs in both English and I think in Hebrew as well, describing the challenges of leaving the ultra-Orthodox community. And one of the most challenging issues identified is the issue of child custody. The parent who is leaving Orthodoxy may wish to retain custody and access to their children as they build their new way of life, while the parent who remains ensconced in the community may seek to limit or cut off all ties with that off the derech parents. In the United States, these disputes are dealt with by civil family court judges who are tasked with finding a solution that is in the best interests of the children. In many cases, this requires them to determine whether exposure to critical views of Hasidic culture in which the children have been raised and alternative lifestyles adopted by the exiting parent are in their best interests. Underlying these deliberations are conflicting notions about the fragility of cultural norms, the meaning of exit, and the right of dissenters to remain in relation to their home community in order to preserve relationships and perhaps to reshape the cultural norms that they are leaving behind. So in this brief presentation, I'm going to argue that new ethnographic research on exiters helps us understand the profound challenges faced by these off the derech parents. Custody cases have become a terrain upon which the broader Hasidic community intervenes to defend their way of life and to send a message to dissenters that exit will be costly and destructive. I further argue that deployment of a gender lens is helpful in understanding the complex challenges presented by these cases. So I'm going to start by focusing on the leading case here in the US, which is Weisberger and Weisberger. Chavi and Naftali Weisberger were members of the Amunah Yisrael Hasidic sect who were living in Monsey, which is a town in upstate New York, when they married in 2002. Once they married, they moved to Borough Park in Brooklyn, another Hasidic enclave, so that the husband could attend Kollel. His studies kept him away from home from morning until night, and Chavi was the primary caretaker for the children. 3 years into the marriage, Chavi disclosed to Naftali that she was not attracted to men and she was attracted to women. But nevertheless, they remained married for a number of years more and had 2 more children. But finally, in 2009, Chavi left the marital home and the Hasidic community, and the couple were divorced. They signed a negotiated stipulation of settlement at the Beit Din of their community that was then filed with the civil courts and was thereby incorporated into the civil divorce decree and became enforceable by civil law. This agreement gave primary custody to Chavi and joint legal or decision-making custody to both spouses. It also included the following clause on religious upbringing. These religious upbringing clauses have become a sort of boilerplate or standard form that is used in cases involving Hasidic couples. They said, the parties agree to give the children a Hasidic upbringing in all details, in home or outside of the home, comparable to that of their families. This becomes important later, 3 years later, to be precise. So in 2012, Naftali, the husband, came back to court seeking to get sole custody of the 3 children. He argued that in the intervening years, Chavi had radically changed her lifestyle in ways that violated the religious upbringing clause that she had signed. She had come out as a lesbian, she had abandoned Hasidic dress and hair covering, and she had shared her views disparaging Hasidic norms and practices with the children. Moreover, when the children were with her, she allowed them to wear non-Hasidic attire, to violate Shabbat and Kashrut. She exposed them to non-Hasidic books and videos and allowed a transgender friend to stay over in her apartment while they were there. The husband argued that he had expected that she would keep her new religious beliefs and her sexuality a secret from the children and from the Hasidic community. Now that it was out in the open, he wanted to reduce or eliminate her role in the children's lives. At trial in the New York Supreme Court, the judge accepted the husband's argument. The existence of this religious upbringing clause was deemed compelling evidence of what was in the best interests of these children. The judge made an order removing the children from the mother's custody, limiting her access so that she could only see them under therapeutic conditions, under the supervision of a social worker in a public place, and ordered her to comply with the religious upbringing clause. This not only meant that she had to ensure that the children observed all principles of Hasidism while they were with her, but also the judge ordered that Chavi herself must practice full religious observance in accordance with Hasidic practices during any contact with them. This order was appealed and the appellate court reversed this decision in 2017. They reversed the part that purported to regulate Chavi's religious observance, noting that the religious upbringing clause really just dealt with how the children should live, not how the mother should live, and also that the First Amendment to the American Constitution means that the state can't impose religious observance on anyone. But more importantly, it found that it was not in the best interest of the children to be required to have an inauthentic relationship with their mother, in which she was categorically compelled to conceal the true nature of her feelings and beliefs from them at all times and in all respects, or to otherwise force her to adhere to practices and beliefs that she no longer shared. The court allowed her to comport herself as she saw fit during her time with the children and concluded by urging both parents to compromise. But this is generally good advice in custody hearings, and it is standard advice when the parties do not involve someone who is going off the derech from the Hasidic community. But there are a number of factors that mean compromise is not so easy in these cases, and I'll talk about just a few. One is the fact that the exiters are required to sign these religious upbringing agreements. Exiting parents often agree out of ignorance and under pressure, and often while present at the Beit Din, to contractual provisions that commit themselves to live in accordance with norms that they themselves are trying to leave behind. They often do this with no independent legal advice and without any knowledge of how inconsistent this commitment will be with the new identity and new lifestyle that they are seeking to create. Contractual language similar to that in the Weisberger case shows up in other published custody cases, and this model has become so common that it is also imposed by judges in situations in which the parties never even signed a contract. There is an advocacy group for people who are leaving Orthodoxy called Footsteps, and they have published a guide specifically focused on this issue called Navigating Divorce and Custody When Leaving Ultra-Orthodoxy, which recommends repeatedly, like on every page, that Hasidic exiters do not sign these agreements, particularly in the Beis Din, without getting independent legal advice, because it really puts a stranglehold on negotiations in the future. So that's one factor. A second factor is, as Princess Diana said, there are three parties in this marriage. There is the husband, the wife, and the Hasidic community. And they really act as parties in the case. These cases often involve a plea that any changes to religious upbringing can disrupt the fragility of Hasidic cultural life. Parents who remain are often supported by selected therapists and religious expert witnesses from the community who argue that the child's connection to Hasidism will be undermined if they are exposed to multiple different normative frameworks. And indeed, in his testimony at trial, Naftali Weisberger testified that there is no place for compromising in our religion. This point of view, I think, is widespread in the Hasidic community. And indeed, I first heard about religious upbringing agreements in a panel discussion that was focused on the Netflix film Unorthodox. And there was a woman who came to sort of explain the values of her Hasidic community. And she very smugly pointed to the fact that we have these religious upbringing agreements that everybody signs, so that when custody cases involving exiters, while they might have gone unnoticed in the past, the Hasidic community is now mobilized to fight these claims in court. This includes crowdfunding charitable campaigns in the community to pay for lawyers for the parent who remains inside. And I'm just going to share my screen for a minute. Initially, this paper had some quotes from other crowdfunding campaigns in the past, but there is now a campaign going on in the Weisberger case. So this, through the wonders of Facebook, this was shared with me last week. And this is a crowdfunding campaign that opened, I believe, on Thursday, and now has raised $929,000. $929,000 to pay for the legal fees of Mr. Weisberger in a dispute that has now returned to the court. And you can see there are 34 teams. When I counted yesterday, there were 9,400 contributors, some giving as little as $18. And just, I wanted to show you the nature of the plea that is being made to the community. So you can see the screen, the situation is critical, but you can help to save a Jewish family. I think they've changed some of the text. But basically, this is the Weisberger case, and Mrs. Weisberger has gone back to court asking that the children be removed from Hasidic schools because of the threat of COVID, that Hasidic schools in New York City, she argues, are not taking appropriate precautions with regard to COVID, so she wants to take them out of the schools and put them in a different school. And the community has joined together to reject that and support his campaign. So truly a David and Goliath kind of situation in what might to a judge look like an ordinary custody dispute. Support for parents who remain in the community may also come in the form of testimony, which distorts the truth in order to achieve the overarching objective of saving children's souls. The anthropologist Schnur Zillman-Neufeld, in his new book, Degrees of Separation, Identity Formation When Leaving Orthodoxy, quotes an ultra-Orthodox informant who was very clear about this. She said, "We don't just live for this world, we live for eternity, for the next world. So the community will always back the parent that stays from. We're not democratic enough to say, oh, you're the mother, and you want to take your children with you. You have a right to go off the derech with your children. No, we don't see it like that. We're fighting for the future of the child." This informant also tells Neufeld that secular judges don't understand these kind of spiritual claims, so it's appropriate to couch their objections in claims that the existing spouse is unfit due to mental illness. So what does gender have to tell us about these cases? A cursory examination of these the public cases suggests that both men and women are likely to be caught up in conflictual custody disputes when they seek to exit Hasidism. And I don't have evidence that off the derech custody disputes are necessarily worse for women, but I think they can be different. Gender does play a role in how these cases play out. Feminist political theorists have argued for decades that it is more difficult for girls and women to leave comprehensive religious minority communities, and recent ethnographic research on exiters from the Hasidic community, particularly in New York, bears this out. And New York is the locus of most of Hasidic life in America. The notion of exit does a lot of work in political theories of multicultural accommodation, in considering when or if the state should intervene to alleviate practices that infringe on the rights of women. Failure to exit the community is often cited as evidence that these practices are acceptable to those subjected to them. An emphasis on exit also allows the practice to act as a sort of safety valve that allows a community to preserve its inegalitarian practice by thrusting out those who are critical. Feminist political theories of multiculturalism that take gender into account have argued for a more textualized and realistic right of exit, which would both take into account the special barriers to exit that impair its use by women and the sorts of supports for exit that should be provided to enable it. And I think I'm arguing that sensitivity to factors like the complexities in these off the derech custody disputes is one of the realistic supports for exit that may be necessary to enable women to move on. New research on ultra-Orthodox exiters supports this. A 2016 survey by Mark Trencher, which spoke with 885 Americans who had left Orthodoxy, found that discomfort with women's inequality under ultra-Orthodox life was the most common reason given by women as their motivation for exit. A slightly earlier study by Lynn Davidman found that nearly half of women and a significant number of men left Orthodoxy in order to seek a life with greater gender equality. In her recent book, Hidden Heretics, Jewish Doubt in the Digital Age, anthropologist Ayala Fader provides evidence for how gender shapes the capacity to articulate, explore, and act on feelings of dissent amongst ultra-Orthodox Jews in New York. And she finds that gender disadvantages women at every stage of this process. I'm almost done. Women may struggle to find a language to express their dissent. Men educated in the intricacies and justifications for Hasidic practices can express their dissent through critique of the reasoning of their leaders, but women lack the education in text and vocabulary to engage in this critique. Dissenting women often are treated with greater hostility and less patience than dissenting men. They are pathologized, their dissatisfaction is ascribed to mental illness, which should be treated with medication, and their pathology is often sexualized as well. They also tend to have fewer material and social resources. Having married early and having children early They are tied down and subject to control by a spouse in ways that men are not. So to conclude, for both men and women, this ethnographic research suggests that exit from an ultra-Orthodox comprehensive community is not simply a moment, but a process. Exit involves changing habits of mind, embodying practices of dress, eating, grooming, comportment, and sexuality. It's not a dramatic break with the community, but a renegotiation of identity that may go on for years. And indeed, Mark Trencher's study finds that for over half of the exiters, their families came to accept and understand them in time. And this change went on for up to a decade. In Weisberger and similar cases, Hasidic couples broken apart by exit are frequently encouraged to work together to consider, address, and help their children surmount the challenges posed by their separations. However, in order to be able to act on these admonitions, courts need to take into account some of the unique features of these custody disputes: religious upbringing agreements, the involvement of third parties, and the fact that exit is traumatic for all parties. Thank you.
Thank you, Lisa. That was fascinating. So now we move to our next speaker, Professor Jan Feldman, and she has been a professor in the political science department at the University of Vermont since 1982. Her research interests include democratic theory, citizenship theory, liberalism, religion, and gender. Her research projects have taken her to the Soviet Union, Kuwait, Israel, Tunisia, Morocco, and among her recent publications is Point Men: How Religious Women Soldiers May Restore Israel's Citizens Army. And she has also authored a book titled Citizenship, Faith, and Feminism: Jewish and Muslim Women Regain Their Rights, one of many other books and publications. So Professor Feldman would be speaking about public purposes at cross purposes. Can segregation lead to integration? What we can learn from Israel? And if you can please present your paper in 15 minutes so we can have also enough time at the end to have some questions. And hopefully also you'd be able to answer these questions as well. So Professor Feldman, please go ahead.
Thank you. I'm pleased and flattered to be participating with so many scholars who've actually had a direct impact on my own thinking. And my hat's off to all of you in Israel who are spending, I think, your first day out of lockdown in front of your computers. Anyway, so look at Israel, as you know, faces a looming economic crisis constituted by a growing population of Haredim, ultra-Orthodox Jews, who live under the poverty line at about 52%. As compared with 19% of the general population. Having to support a community which neither works nor serves in the military has generated a fair amount of resentment among other Israeli taxpayers who see the Haredim as cashing in on the benefits of citizenship without bearing the costs. So in response, in 2011, Israel's Council on Higher Education, which is part of the Education Ministry, I'm going to call it CHE or Malag, instituted a program that intended to integrate Haredi students into Israeli universities, ultimately the workforce, which is a laudable project. But the problem is it capitulates to the Haredi claim of a cultural right to study in gender segregated classrooms with all male faculty. And that gives the imprimatur of the state to gender discrimination. And this is no trivial matter. Detractors perceive the CHE plan as part of a broader agenda intended to dismantle liberalism, replace civil law with Torah law, and erase the distinction between religion and state. Conversely, Haredim and their supporters accuse the plan's critics of mounting an attack on the Torah way of life through a campaign of forced secularization. So there's a legal case, no surprise, languishing before the Bagatz, the High Court, since 2017. Last July, 2020, Judge Hanan Meltzer provisionally determined that gender segregation in academic institutions runs afoul of the principle of equal opportunity in employment laws. The final ruling isn't expected until October of 2021, and I think we can project that whatever it turns out to be, no one's going to be satisfied. And that's because the case reveals cleavages that go to the very core of the Israeli state's identity as both democratic and Jewish. It occupies the intersection where religion and state collide, where group cultural rights and individual rights collide, where a unitary civic state and legal pluralism collide. So this paper assesses the CHE program. If the assessment were restricted to pragmatic concerns, the question simply stated might be, is the program succeeding in its stated goal of integrating Haredi Israelis into academia and the workforce? Yet even if the CHE program were successful in this respect, and spoiler alert, right, evidence suggests that it's not, there would still be unresolved normative and legal questions. Secondly, the case raises conflicting models of citizenship. Should we, or should Israel, structure belonging according to the ideal of a civic state composed of equal individuals under a unitary legal system? Or should it be structured as a collage of nomic minority cultures, which choose to belong on their own terms, according to their own authoritative laws, as kind of partial citizens? Now, as you know, Israel inherited the Ottoman millet system, which is kind of a forerunner of modern multicultural accommodation, and it defers to constituent subgroups, but it still holds the espoused liberal model of democracy. Now, Israel's not alone in this predicament. Even UN treaties and conventions struggle to balance individual rights against commitments to cultural and group rights. So Israel's Ministry of Education, of which CHE is part, seems to favor the latter by permitting the Haredi communal and parental near autonomous control over education. So the problem then is that CHE's program is at cross purposes in a number of ways. First of all, it leaves intact the exemption that Haredi boys have from acquiring what we call STEM skills, basic skills, English, math, science. And given that Israel is known as the startup nation with a high-tech economy, that gives a competitive edge, obviously, to people with higher education. So this leaves CHE's program unrealistically relying on institutions of higher education to make up that obvious shortfall in Haredi boys' education. And it's compounded by legislated exemptions of Haredim from military service, which is the other path that Israel offers to acquiring workplace skills. For our purposes, the CHE plan is at cross purposes with both Israeli law and liberal norms. However, proponents of the CHE plan cast it as an absolute textbook case of affirmative action and multicultural accommodation. For instance, in the name of helping minority cultures resist informal pressures to assimilate to the dominant culture, many liberal states grant them some latitude, often in the form of exemptions from otherwise generally applicable laws. We also know that multicultural accommodation is not necessarily a boon to all members of the minority culture, especially women. By recognizing and negotiating with authoritative heads of minority subcultures who are typically men, the state may reinforce internal patriarchal power relations. Moreover, multicultural accommodation typically doesn't permit minorities to impose their values on the majority. Similarly, the CHE plan is often characterized as affirmative action. The Israeli legislature for decades has recognized affirmative action as one of the main mechanisms for realizing the principle of equality. So here you have a group in which 25 to 35-year-olds, only 2.4% of Haredi men and 8.3% of Haredi women hold degrees in higher education. So if affirmative action applies to underprivileged or marginalized groups, why not Haredi? But if affirmative action programs are intended to advance marginalized groups whose status is a product of formal or informal discrimination, should it apply when the marginalization is the result of voluntary self-segregation? Unlike typical target groups, Haredim are not politically powerless or underrepresented. On the contrary, Haredi and secular allies in the Knesset have quite a bit of political power, and they are adept at magnifying it. So the perpetuation of Haredi poverty may not be due to discrimination, but perhaps to Haredi privilege, wherein the government responds to the rabbi's demands for exemptions from the very paths to social and economic advancement that are available to other Israelis. Okay, so how did gender segregation become a path to Haredi integration? In 2011, professor and economist Manuel Trachtenberg, who's chair of the Planning and Budgeting Committee of the CHE, sensed that Haredim were increasingly restive under their own regime of enforced poverty. Some of you may be familiar with Adina Bar Shalom's attempt in 2000 to create the Haredi College with the blessing or tacit approval of her father, Ovadia Yosef, who was then Sephardic chief rabbi of Israel. Meanwhile, academic institutions recognized an untapped source of financing in recruiting Haredi students and accepting government subsidies and funding. So the CHE announced a program called Increasing Access to Higher Education for Ultra-Orthodox Jews, a plan for the integration of Haredim into academia, and allocated a rather enormous budget, 1.2 billion shekalim, for this multi-year program. The fateful decision to establish gender-segregated settings relied on a survey that the CHE had commissioned from a guy named Asaf Malchi, which concluded that 70 to 80% of Haredi men would only agree to study in university if they were provided with segregated classrooms and all male faculty. Now, a number of people, including our own Professor Yofi Tirosh, Netta Barak Koren, dispute both the methodology, the data, and the findings of this survey, claiming a very different interpretation arises if you exclude from the sample the guys that would never be willing to study in an academic setting anyway. Then the percentage of those willing to study only in segregated, gender-segregated settings would drop to 44%, and those who require segregated campus as a whole drops to 23%, and only 16% define the lecturer's gender as a key consideration. So the conclusion that emerges strongly undermines the factual basis for the CHE policy of gender segregation. Nonetheless, the CHE inaugurated sex-segregated classes first on physically separate satellite platforms and subsequently on main university campuses. The CHE certainly anticipated criticism about these separate classes and responded with the claim that all facilities and all resources would be, wait for it, separate but equal. So, had the programs been restricted to private institutions and attached to smaller professionally oriented colleges, this may have gone under the radar. But the CHE program was complicated by the fact that there were difficulties with administrative and oversight of these decentralized platforms. And so CHE responded by bringing programs onto the campuses of Israel's flagship universities, designating either entire separate buildings or segregated days and hours in the same buildings. And segregated Haredi programs opened on almost every major Israeli campus, including many brand new centers that were built for Haredi students with taxpayer funds allocated by the Ministry of Education. Okay, so the assessment of this program, supporters and critics, as you can imagine, line up. 5 minutes, oh my God. All right, so let me just run down the criticisms then. The program overcommitted taxpayer money, white elephant from the point of view of the taxpayers, right? And it did not succeed in its goals of bringing Haredi students into campuses. And it was gendered, to try to summarize. One of the most astounding failures was that the dropout rate for Haredi men who entered this program under the auspices of Che, 67%. It looks more successful in part if you count Hardal men. Hardal is a contraction of Haredi and Dati Lumi. But Dati Lumi guys join the army and succeed in college, no problem. But they piggybacked on the Haredi guys because it allowed them not only segregated, gender segregated settings, but also exemptions that Haredi boys were given from Bagrut and psychometric exams, which are kind of like entrance exams to university. So it was an easier path into college. If you remove the the Hardal students who were typically successful anyway from the mix, it looks like an even bigger disaster in terms of the goal of integrating Haredi men onto campus. The other problems were category spread in terms of the promise that gender segregation would not affect public spaces, but only classrooms. We know that it spread to public spaces as well. We were also promised that it wouldn't go beyond the undergraduate level, but it is on the cusp of spreading into graduate programs as well. So hence the High Court will have to deal with this lawsuit in which what are clearly the claimed cultural rights of this subgroup conflict with the rights of individual women and faculty members. Now, proponents obviously see this as a tremendously successful program. And interestingly, they pick up the vocabulary of diversity and inclusion and women's empowerment by emphasizing the success of Haredi women as opposed to the failure of Haredi men. But the rub here is that Haredi women have not had a problem either studying or entering an integrated workforce. And part of that is halachic, their interpretation of halakha. Part of it is a very different educational system. And that is the root of the problem. Hereditary sector, there are 4 sectors in the Israeli education system in deference to its multicultural nature. And one of those sectors is the Hereditary sector, where parents and rabbis have near autonomy with respect to curriculum. And despite the 1953 curriculum laws and many attempts by secular parties in the Knesset to hold the Haredi community to providing the uniform basic curriculum, the Haredi community refuses to do that, with the obvious outcome that the boys are quite unprepared for higher education, but the girls who oddly get a more general education do fairly well in higher education. So the boys are pretty much crippled by this program. And as for touting it as a feminist success story for Haredi women who do quite well, they do quite well without the program. So just to wrap it up, what the Che case highlights is a deeper problem than even the educational system. And that's the political power of the Haredi parties and their allies to resist any attempts on the part of the Israeli government to impose curricular reforms or enforce the core curriculum law. So Israel has not achieved a coherent balance between individual students' rights to an equal education versus the rights of parents and religious communities to transmit their values to children. The case should dramatize that the government's deference to subgroup rights ought to have some limits. Now, I think everybody understands how these self-defeating policies can be explained. And again, it's probably the political power of the Haredi establishment, which uses institutions of government and coalition politics to further their own sectoral interests, which is not harmless, by the way, to students. So in conclusion, then, the education ministry maintains that the Che program is the only feasible way to integrate Haredi men into the workforce in the face of political realities which foreclose a more far-reaching remedy. But the critics claim that the Che is overselling the need for gender segregation. and that logically segregation can't be a path to integration. This isn't Israel's first rodeo. They've been down this path before and treated it in a very different way. So for instance, when Bedouins said they wouldn't attend Ben Gurion University without gender segregation, Ben Gurion University provided affirmative action, counseling, tutoring, scholarship support that enabled hundreds of Bedouin women to benefit from higher education and retain a balance between their traditional lives and their education. Haredi students were told by the Technion that they would not have gender segregation in classrooms and that they would have female professors, and they accepted that. The problem is created apparently by the rabbis and not the Haredi students themselves. So the application of tools such as affirmative action and cultural accommodation can help to redress a group's marginal status without doing damage to democracy or liberalism or the rule of law. But only if the target group, in this case the Haredim, embrace integration without denying to others the very principles of toleration, diversity, and equality from which they themselves benefit. So I don't know the end of the story. We'll see what the High Court rules. I'm not entirely optimistic about the result because of the deeper problems, but at any rate, that's as far as I can get in my research to date.
Thank you. Yeah, this was really fascinating, and I guess, like myself, many of the others would have an irresistible urge to comment and say a lot about the issue, but we must move. So our next speaker is Dr. Yofi Tirosh. Yofi teaches at Tel Aviv University, and until recently, she was the dean of the law school at Sapir College. She's an expert in anti-discrimination law, feminist jurisprudence, law and culture. She also combines academic activity with public advocacy to prevent hadarat nashim, in Hebrew, the exclusion of women. She is the recipient of the prestigious Gorny Award by the Israeli Association of Public Law, and she is the author of a recent article titled "Diminishing Constitutional Law: The First 3 Decades of Women's Exclusion Adjudication in Israel," which is forthcoming in the prestigious Icon journal. So Yofi would be speaking on the topic of women, religion, public spaces in Israel, contemporary challenges. Yofi, the floor is yours.
Thank you very much, Michael, and thank you to the organizers for the invitation to this fascinating conference and conversations we've been having. My presentation is a perfect continuation of Professor Feldman's presentation, and I'm going to zoom out a little bit and talk about sex segregation in Israel from a more general perspective. So the history of Israeli law and society is abundant with controversies about women's legal status and civic place. Israel's women have been trapped between the state's egalitarian aspirations, as evident in the Declaration of Independence, as well as in the long line of progressive legislation and case law, and on the other hand, religious notions that allocate specific roles to each sex. Even before the establishment of the state about a century ago, and here I think we have Margalit Shiloh in this Zoom room, and I'm grateful for her book on called Girls of Liberty that told this story in a wonderful way. So in the pre-state years, prominent rabbis such as Harav Yitzhak Cohen Cook demanded that women would not be permitted to vote in the elections to the Zionist bodies of the Yeshuv, threatening to boycott these proceedings if women were to be enfranchised. Similarly, a demand was voiced that sitting in the popular assembly, the precursor of the Knesset, would be physically divided so that women sat at the back, as in the Orthodox synagogue, Not without a fight, these demands were rejected. Attempts to strike the right balance between Israel as a Jewish and as a democratic state have been charging a high price for women in many contexts. The monopoly of religious law in marriage and divorce is a major example, of course, but it is not the only area of tension between liberal and religious perceptions of gender. Before I continue, let me clarify that I do not mean to suggest that the liberal secular side of the equation is free of deep patriarchal structures, far from it, but it requires a different analytical framework that I won't have time to get into today. So Hadarat Nashim, Hebrew for women's exclusion, is a term that has come to signify in the past decade a wide array of practices that instruct women to stand aside, move to the back, or keep out, dictating that women cover their bodies and hair, conceal their bodily contours, lower or silence their voices, and abandon expectations to partake in public life, be it religious, political, civic, artistic, professional, or financial. Common to all exclusion conventions is the aspiration to constitute a social order in which women's place, life opportunities, and destiny are determined by their sex. Underlying exclusionary norms are essentialist views of femaleness and femininity. Inwardness, modesty, silence, obedience, domesticity, motherliness, service, and care are among the qualities that exclusion practices assume as women's essence, seeking to further instill in them, thereby also redefining normal womanhood. The contrasting qualities, outwardness, physical presence, independence, disobedience, self-preference, voice, or leadership are to be tamed since they undermine sexual piety and blur sex differences, which are the basis to morality and family values. Women's dangerous sexual nature, demonized as uncontrollable and always to blame, requires meticulous supervision and restraint. How have Israeli courts responded to Hadarat Nashim? I would like to suggest that judicial responses have been mixed. When exclusionary practices are blatantly discriminatory, the courts have been resolute in developing legal means for compensation and prevention. But when sex segregation is in itself is under review, the judicial response have been far more hesitant. Israeli courts have been reviewing women's exclusion cases under public law and under private law. Petitions against governmental bodies have been examined through the lens of constitutional rights such as dignity and equality. The right to equality is not explicitly enumerated in Israel's basic law of human dignity and liberty, but it has been recognized as part of the right to dignity. Or under administrative law doctrines. Civil courts approach women's exclusion cases through a tort lens, awarding damages for violations of anti-discrimination statutes in employment or in the service sector. Under both normative frameworks, courts have found it easy to recognize the harm to women in cases in which they have been evidently treated adversely. For example, damages were awarded against a bus company whose driver refused to let a young woman embark on a bus because he felt her shorts were not modest enough, or against El Al when a female passenger was asked to move to a different seat to accommodate an ultra-Orthodox man who refused to sit next to a woman. Sometimes such rulings are accompanied with reasonings that express judicial shock and denunciation. Even when the discriminatory treatment in question is not initiated by a particularly pious individual, a social actor, but when exclusion is arguably part of a collective right to religious community autonomy, Israeli courts have articulated resolute responses against it. This was the case when the Haifa District Court declared that it was illegal for the mayor of Haifa to fund a concert by a popular Haredi singer, Moti Steinmetz, open to men only. Another example is the case of Kolech versus Kol Barama Radio, a pioneering class action against a Sephardic Haredi radio station that would not broadcast women's voices. not only singing, but also talking. The station was made to pay compensation for discriminating its female audience in violation of the law banning discrimination in products and services. Courts have also been able to restrain attempts to ban women from serving in roles that are at the vicinity of religious leadership. Under Israeli law, nominations to core religious roles such as municipal or national rabbis or qadis, who in Israel are paid public servants, can be reserved exclusively to men in recognition of the Orthodox approach that disqualifies women from these roles. Such nominations are not subject to equal opportunity laws. But the religious establishment has been trying to expand male exclusivity to more and more roles. Throughout the years, it has maintained, for example, that women could not serve in committees who selected city rabbis or as general managers of the rabbinical court system, nor as arbitrators in divorce cases adjudicated under Sharia law. An impressive line of case law has recognized that these positions fall outside the scope of the roles that religious law conservative interpreted saves exclusively for men, declaring that women are entitled to fill such roles. Sex segregation, however, has been more conceptually challenging for courts. Unlike the case described so far, here, at least arguably, there was no adverse treatment to women. The underlying justification, we heard it in the previous presentation, is that the sexes can be separate but equal. Much due to the fact that many Jewish and Muslim religion communities practice segregation in public prayers, schools, festivities, and many other contexts, depending on the community in question, sex segregation seems less suspicious than segregation based on race or nationality. In the context of segregation between Jews and Arabs in housing and between Ashkenazi and Mizrahi students in education, Israel's Supreme Court has followed the steps of the US Supreme Court in Brown versus Board of Education and rejected the notion that the separate can be equal, finding that segregation is discrimination. Segregation between men and women, however, has not been met with similar condemnation. Sex segregation has first surfaced in Israel's education in the 2010 case of Reagan versus the Transportation Ministry, in which the High Court of Justice examined the legality of segregation on buses. The Supreme Court's critique of this practice focused on making sure that women were not forced to sit at the back of the bus, but the ruling did not flatly reject this seating arrangement in and of itself. Quite to the contrary, in designing its final injunction, the court instructed to use means that would prevent using force against those not abiding by the segregation convention. But it also explained that it wanted to make sure that women who do want to sit at the back were still able to do so. Hence, it ordered to leave the back door open. In the past decade, we've seen a surge of litigation against sex segregation. Unlike Reagan or the women's exclusion cases I mentioned before, these cases involve segregation initiated by the state or by other public authorities. There are two contexts in which sex segregation is justified by public authorities. In the first, segregation is presented as essential for achieving a legitimate policy purpose, namely encouraging Haredim to integrate and increase their participation in academic studies, as we heard before, the labor market, the military, etc. The argument here is that without segregation, Haredim will not partake in such activities. These segregation policies have been challenged in courts several times. In full disclosure, I'm leading a pending petition against segregation in academic studies, and this room is abundant with partners to these efforts, Professor Stopler, Professor Raday, the Rachman Center. It takes a village to lead such a petition. But so far, no clear doctrine has been provided. In case after case, courts have been signaling ambivalence and uncertainty about the appropriate legal framework for assessing sex segregation. Most cases thus far have ended with compromise between the parties that receives court approval. The content of such settlements indicates that most courts feel that sex segregation in contexts such as professional training or academic studies is not to be treated as so suspicious that it could hardly ever be legal, but that its harm to basic rights should be balanced vis-a-vis its benefits. To employ American legal terms, courts feel that sex segregation is not so suspicious such that it should be strictly scrutinized, but rather that it could be justified if it passes a proportionality analysis. Gender distinctions then are only quasi-suspect. One indication for this judicial tendency is that in the settlements that resolve those cases, the government commits to provide empirical data on the extent to which its segregated programs achieved their goals, produced the desired outcomes, if and when these programs come again under judicial scrutiny. The second context in which public authorities protect sex segregation and justify it is as a form of substantive equality, which would enable Haredim to enjoy activities and services that they would arguably not be able to enjoy without segregation. Here, segregation is a form of accommodation. This justification was invoked to defend a summer 2019 segregated concert in Afula, which was the center of a heated public controversy. The district court's ruling that the city of Afula funding the event was not allowed to use ushers or signs to instruct men and women to sit separately was approved by the High Court of Justice. However, these relatively resolute decisions drew a contradictory ruling from another district judge who valorized cultural autonomy as enabling diversity and pluralism. Moreover, the Afula ruling that after the Afula ruling, the Attorney General issued tentative guidelines indicating not only that providing segregated municipal services can sometimes be allowed, but in some cases it would be the duty of the municipality depending on the town's demographic makeup. I'm reaching my conclusion. Also under the argument of necessary accommodation, in the past few months, a plan surfaced to offer segregated visiting hours in natural resorts to enable modest bathing in springs and freshwater ponds. At first sight, such steps may seem like reasonable accommodation indeed. I cannot elaborate on why this is a misleading perspective. So let me just say that when public authorities offer services or activities under sex segregation, they partake in the architecture of discrimination as a default social design. Rather than accommodating the religious public, it enforces segregation on many among it, particularly, but not only, women who may not be interested in extending segregation norms beyond the synagogue, the mosque, or their children's school. In the natural resorts example I just mentioned, an ultra-Orthodox friend recently told me that separate recreational times for men and women would mean that even in the Passover and Sukkot holidays in which her family goes out to trips, these are the only times in which they are together as a family. They will now have to be separate in order to enjoy nature, she and her daughters apart from her husband and her sons. In closing, Israel's adjudicators, it seems, will soon be compelled to rise to one of the most pressing civil rights challenges in Israel and develop and articulate a principled normative stance on sex segregation, a growing phenomenon that is not only a litmus test for the situation of women and gender, but poses a literal danger in and of itself to women's equality, liberty, and dignity. Thank you.
Thank you, Yofi. That was fascinating. And now we move along to Francis Raday, the Elias Lieberman Professor Emerita in labor law at the Hebrew University, a colleague and friend. And Francis, I took the liberty as a previous dean to pull up some information about you. So I still have some prerogatives. So Francis is currently the head of the Concord Institute for the Study of the Absorption of International Law in Israel at the College of Management. And this is a position she took after she retired from the Hebrew University, but she's still teaching at the Hebrew University, and we were very happy to have her. And she has held a number of positions at the United Nations. She's been a special rapporteur of the Human Rights Council and was the chair of the Working Group on Discrimination Against Women, and is a former member of the committee to eliminate all forms of discrimination against women. She's the recipient of a number of honors, 2 honorary doctorate degrees, and she is the recipient of the Chechen Award and the Barneve Prize for Labor Law, and that's among many of her other achievements. And Francis would be talking to us today on religion, culture, and gender, current developments in international human rights. Francis.
What I wanted to do, I hope, well, in fact, I'll go back and say thank you. All the speakers today have been really wonderful, and what I want to do is very quickly try and share with you my experience of the way that resurgent fundamentalism, religious fundamentalism, is expressing itself at the international level as well. Of course, we start off with women's right to equality as key to human rights. In international human rights law, since the Universal Declaration of Human Rights, since the International Convention on Civil and Political Rights, and since, of course, the CEDAW Convention in 1980, which is an international bill of women's human rights. And what is happening to that under the onslaught of religious fundamentalist state positions? Well, you know, we heard of the wonderful, impressive, admirable, and necessary religious feminist hermeneutics, but nevertheless, the predominant religious interpretations which are prevalent in the 21st century have not abandoned the patriarchal ethos of religion. They are also homophobic and hostile to LGBTI rights. I will talk more today on women's rights, but please extend a lot of what I say to this sphere of LGBTI rights as well. And the traditionalist regimes of orthodox religions are posing an ideological challenge to the international human rights regime's clear mandate of equality for women. And it's in direct conflict with CEDAW's requirements, that's the Convention for Elimination of Discrimination Against Women, for the requirement of formal and substantive equality for women on the same terms as men, as well as the call for transformative redistribution of resources and power between women and men. State reservations to the CEDAW Convention have been focused on the refusal of states to apply women's right to equality where it conflicts with religious norms. And these states have thus themselves identified religion as the core source of resistance to international human rights of women to equality based on religious patriarchy. The religious challenge to universal human rights is especially poignant, especially strong as regards, as I said, women's right to equality and recognition of the gay community, LGBTI rights. And it has intensified over the past decade. A series of human rights council resolutions have been promoted by the Organization of Islamic Cooperation and Russia and passed by a majority of the council's 47 member states. And these resolutions have attempted to redraw the boundaries of human rights by calling for the interpretation of human rights in accordance with traditional values, by calling states to prohibit the defamation of religion, by calling states to give protection to the family unit, protection of the family, without including a guarantee for women's right to equality in the family, which of course stems back to 1948 to the Universal Declaration of Human Rights and is detailed in the CEDAW Convention. The human rights independent experts in the treaty bodies and in the special procedures, that's the special rapporteurs, and in international human rights organizations have consistently rejected these regressive attempts. And they have so far been reasonably successful in that there has not been any real change to the norms of international human rights law as yet, though there are these opinions which are threatening us on the very close horizon. The special rapporteurs, as I say, these are the independent human rights experts, not the states. I regard the states as the political branch of the Human Rights Council. The independent experts in the treaty bodies and the special rapporteurs are the human rights defenders, I would say, of the international human rights system. And they have said time after time that freedom of religion cannot justify discrimination against women. Amor, who was the special reporter on freedom of religion, Abdel Fattah Amor, said the longer we postpone tackling it, he referred to the many ways in which religions rationalize and legitimize discrimination against women, and remarked that the longer we postpone tackling it, the greater the risk of embedding gender inequalities in the field of human rights. He emphasized women's rights, even when involving cultural and religious aspects, form part of the fundamental rights of the individual. Universality arises out of a concept which is at the very root of human rights, the substantial and inherent dignity of the person. When women's dignity is infringed upon, there is no place for sovereignty or for cultural or religious distinctions. And this has been repeated by the Human Rights Committee, by the CEDAW Committee, and by my own committee, the committee on which I was working, the working group of which I chaired, the Working Group on Discrimination Against Women. But it has become more of a tussle. The current special rapporteur, Bielefeld, had a joint working session with us and had to be persuaded to adopt the approach which had been previously set out by Abdel Fattah Amor. There are 4 issues over which the challenges are appearing in concrete terms. I'll go through each of them very briefly. The right to equality, to women's equality in the family, abortion, the right to reproductive rights, gendered modesty, which we've been hearing about as regards sex segregation in Israel, and the LGBTI right to equality. So let me look at these quickly. There is a strong religious challenge to women's established right to equality in the family. The family is a central situs for the religious challenge to women's right to equality. In 2014, the Human Rights Council, in its resolution of protection of the family, refused to include a reassertion of women's right to equality in the family, which, as I have said, was recognized, guaranteed under the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights, and the CEDAW Convention. After a battle which I waged as chair of the the Working Group on Discrimination Against Women, the Council made a partial concession, recognizing, and I quote, that equality between women and men and respect for all the human rights and fundamental freedoms of all family members are essential to family well-being and to society at large. But this, of course, falls short of reiterating women's right to equality in the family. So this is an ongoing struggle. In its annual resolution in 2015, the Human Rights Council, because there's an annual resolution on discrimination against women, which the Working Group on Discrimination Against Women made, in which we made recommendations to the Council. And the recommendations we made was to enshrine women's right to equality in the family in constitutions and in law, whether in secular, plural, or religious family law systems. This, the Human Rights Council did not adopt in its annual resolution. So you can see the resistance of the states at the level of the Human Rights Council to fully adopt the right of women to equality in the family. Now, there has been a strong religious politicization and prohibition of abortion. The politicized Catholic and evangelical right is making a concerted effort in countries in many regions to retain or even introduce new prohibitions on the termination of pregnancy, as for example in Poland and Lithuania. In the United States, there have been inroads against Roe versus Wade, funding for against funding health insurance for contraception, the global gag rule, which affects US aid to clinics or to countries which give advice on abortion, counseling on abortion. In some South American countries, and this is getting worse in some of them, better in others, abortion is almost entirely prohibited, including for pregnant girls aged 10 or 11, and women are being prosecuted for murder with 30-year prison sentences. The World Health Organization says that there are approximately 22 million unsafe terminations of pregnancy annually in the 25% of systems, or 25% of women who are under restrictive legal systems regarding abortions. And this results in 47,000 deaths annually. Progress, this was a new trend to allow abortion. Progress was made in the Working Group on Discrimination Against Women, in CEDAW, and in the Council on the Status of Women between 2014 to 2017 to decriminalize abortion, to allow abortion on request for the first trimester, and to recognize wide social grounds for abortion after that. I can't go into details, and this is each of these bodies, these mechanisms made slightly different contributions to this more progressive approach to termination of pregnancy. The working group called for making abortion accessible and affordable. This progress has been undermined by a decision on the right to life of the Human Rights Committee. The Human Rights Committee is the committee that monitors the International Convention on Civil and Political Rights. And in 2018, they gave their general comment on the right to life, and they restricted the grounds for abortion to situations where carrying a pregnancy to term would cause the pregnant woman or girl substantial pain or suffering, most notably where the pregnancy is the result of rape or incest or is not viable. This is one of the narrower grounds for allowing abortion. According to inside information that I had while I was in Geneva, the more restrictive approach to the right to abortion was a result of insistence by Catholic members of that committee. The third situation I'm going to talk about is the case of gendered modesty. I think that religious control in the public and political space is really characterized by the religious revival regarding women's modesty and sex segregation. It's a front line for religious revival. And we've seen how it's occurring in Israel, where Judaism is the majoritarian religion. It is true in some Muslim majority countries, and it is true in some minorities in Western countries, in Western democracies. In the theocratic regimes, it's imposed by the state. In the democratic regimes, it exists in traditionalist or majorities or sub-communities, where it may or may not be at the free will of the women and girls, because they may be under community pressure, even if they're not under state pressure. We'll hear of the Begum case in the United Kingdom Supreme Court this evening, where I called for a window of opportunity for girls from patriarchal backgrounds to experience equality in state schools. And this was quoted by Lady Hale. And again, it's the opposite from the way that the Israeli judiciary has been moving towards sex segregation in Israel. In Islamic community, as regards Islamic minorities in Europe and gendered modesty, I call the gendered modesty, not modesty which is applied equally to men and women, but modesty in which the obligation is imposed on women to observe the gender norms. So we have had cases on the wearing of the burqa in Europe, and the SAS versus France case in the European Court of Human Rights, where France imposed a legislative ban on wearing the burqa in public places. So the European Court ruled that the burqa does not discriminate against women, as one woman had asked to wear it, but upheld the ban nevertheless, because wearing the burqa, which concealing the face in public, raised a barrier against others, which could undermine the notion of living together. The Human Rights Committee in 2018 in Yeka versus Heredity found that the French law did violate the International Convention of Civil and Political Rights to religion, freedom of religion, and to equality before the law. They said, although the burqa is potentially discriminatory, unlike the European Court, the blanket nature of the ban penalizes the very women such a ban would purpose to protect. Consequently, they suggest less intrusive measures could have been adopted, such as education and awareness raising, not a ban. I can't go into detail because I'm bringing you the whole range of things, but of course the European Court's decision that it wasn't discrimination in a very categorical way is, in my view, very problematic, though its idea of living together as being a reason for banning the burqa seems extremely unsatisfactory. In terms of the Human Rights Committee, the acknowledgement that the burqa, this gendered modesty, was and could be discrimination against women is welcome, but the idea that the way of getting around it would be by education and awareness raising is certainly a long-term project and doesn't give a satisfactory solution of immediate relevance.
Francis, can you try
finishing,
to 3-4 minutes, that'll be good. Thank you.
I'm going to leave the discrimination against LGBTI, where the European Court of Human Rights was a pioneer of prohibition of criminal prosecution of homosexuals, which was subsequently led to legalization of homosexuality in Ireland and in the United States Supreme Court. It has not yet reached the stage where the European Court of Human Rights is prepared to endorse same-sex marriage. So I'm going to leave that very briefly, and I'm going to summarize, and I'm going to say, while hermeneutic change to bring out women's equality under religious precepts is to be welcomed, this will require a transformative change in the dogma and the practices of each of the Abrahamic religions. In the interim, until this is achieved, under the equality paradigm of international human rights law, states must provide access to justice for women who seek their right to equality in all spheres of life without the barriers created by religious and cultural patriarchy. Women's rights to equal personhood in the leadership roles, functions, and rituals of their own religious communities should also be recognized and encouraged by the state. What is happening at the moment at the international level is that politicized religion is undermining the international human rights law guarantee of equality for women, which we have enjoyed for 70 years. Thank you.
Thank you, Francis. That was wonderful. Now we get to our respondent, Professor Gila Stopler. and she is currently the Dean of the Law School and an Associate Professor at the College of Law and Business. She serves as the Editor-in-Chief of the Journal of Law and Ethics of Human Rights. She also serves on the advisory board of the International Journal of Constitutional Law, ICON, and she is co-chair of the Israeli branch of the International Society of Public Law. Gila's area of expertise include constitutional law, comparative constitutional law, religion-state relations, multiculturalism, women's rights, and democratic erosion. Gila, I hope that 10 minutes would be okay. If not, you have an extra 2 minutes as well. Gila, please.
Okay, thank you very much, Mikhail, and thank you very much to the organizers for inviting me to respond to these 4 very interesting, thought-provoking, and important papers. I find myself in a difficult position since, in principle, I agree with almost everything that has been said in the papers. And plus, I only have 10 minutes to respond to all 4 papers. So what I did, I was just decided to focus on one point in each of the papers in the order of the presentations. And I apologize in advance to these really, really wonderful speakers that I will not be able to do justice to the depth and the intricacy of either of their presentations or papers. So I'll just start with Professor Fishbayn Joffe's paper. And I appreciated the fact that her paper highlights 2 of the faults of liberalism and of liberal states in dealing with the conflict between women and religious communities. One of them is that, that Yofi already mentioned, is that liberalism itself is patriarchal. So in the context of this paper, its patriarchal nature is exposed first in the centrality that it gives to notions of exit and consent, which serve as a convenient excuse to reject women's demands for justice and fairness within the community. And second, in the lack of understanding of what exit entails in the real lives of women in religious communities, who are often torn between their need to escape oppressive conditions and their commitments to their children, and who will sign any contract, sometimes without understanding the consequences in order to be able to escape. Liberalism's second fault is that it is unrealistic, not only with respect to its lack of understanding of exit, but also in its lack of understanding of the power that patriarchal and highly conservative religious communities hold over their members, and the length that they will go to, as we saw in the presentation, to fight the exiting parent and to keep the children in the community. Because liberals are happy to declare their commitment to equality in the public sphere, but using concepts such as the public-private distinction, exit, consent, and toleration to maintain the hegemonic patriarchal power structure, including that of religious communities in the private sphere. So I was therefore wondering if Professor Fishbayn Joffe is not too optimistic when she expects American courts to be critical of Hasidic parents who refuse to teach their children to respect the lifestyle of the more liberal parent. A major problem with liberal toleration, as I understand it, is that it traps liberals in a vicious circle in which the more extreme and exclusionary the community to which the parent belongs, the more understanding the courts are likely to show to the refusal of the parent to expose his children to other worldviews, since allegedly such a refusal is an indispensable and central part of his religious belief. So I wonder if the court that scolds the modern Orthodox for educating her children against Hasidism will similarly scold the Hasidic man for educating his children against secularism. This point is also at the heart of the gender segregation in the public sphere in Israel due to Haredi demands, which Professors Feldman and Tirosh discuss. As described so well in Professor Feldman's presentation, both the initiation of the segregation and its gradual expansion have been based on a Haredi claim that gender segregation is an indispensable and central part of the Haredi way of life and of their religious belief. Each attempt by the state to limit the sites of segregation is met with a new religious edict, which expands the areas of required segregation, and which in turn leads the state to give in and legitimate the segregation, or at least turn a blind eye to it. But my specific comment to Professor Feldman whose analysis is very perceptive, is to urge her to strengthen her critique of the Haredi claim that instituting gender segregation should be understood as a multicultural accommodation. There are three reasons why it shouldn't. The first, which Professor Feldman mentions, is that sex segregation in the public sphere requires the violation of the rights of individuals from outside the accommodated group. The second is that the Haredi community cannot be considered a minority community that needs multicultural accommodation. It is a politically powerful community that controls Israel's religious establishment, holds key positions in the Israeli government through which its representative impose their ever radicalizing religious tenets on the population. Gender segregation is merely an additional channel through which they're trying to do so. It has nothing to do with multiculturalism, and I think it's important for us to realize that. And third, Israel is a weak liberal state due to the extensive role of the religious establishment, its coercive power over citizens, and its extensive autonomy. As a weak liberal state, it cannot accommodate additional illiberal practices such as gender segregation in the public sphere without endangering the very foundations of its liberal democracy, as is shown by the expansion of segregation demands to the Hardalim, which Professor Feldman mentions. I want to tie this into Dr. Tirosh's claim that the court is too hesitant to strike down state-sanctioned segregation. The political power of the Haredim and their partners in segregation, the Hardalim, makes it politically dangerous for the court to intervene, and this is at least partly why it doesn't. However, as Dr. Tirosh points out, another reason is that liberals do not treat sex segregation similarly to racial or to ethnic segregation. Here again, the patriarchal nature of liberalism raises its ugly head. Unlike race or ethnic relations, which are inherently part of the public sphere, gender relations, no matter how oppressive, are always seen as part of the private sphere, the sphere of alleged liberty and assumed free choice. And this connects to Professor Raday's important paper, which is doing very important work in making the case for stricter enforcement of CEDAW. Professor Raday is correct that CEDAW's vision for women's equality is far more extensive than what states actually do to achieve it. CEDAW is more radical than liberalism is. It rejects the public-private distinction. It calls on states to intervene in culture and religion to abolish women's oppression. But there's a huge gap between the vision and the reality, and that gap doesn't seem to close, even as professional independent treaty bodies urge states to close it. Quite to the contrary, as Professor Raday said, it seems to only widen. But it is no accident that theocratic and authoritarian states are not implementing CEDAW, and that even the liberal US has not signed on to it, claiming that that it contradicts even the liberal principle of non-intervention in the private sphere of culture and religion. However, although states perceive CEDAW as radical, when we compare the wording of CEDAW to the wording of the Race Convention, one cannot help but be struck by the difference between the wording. So while the Race Convention rightly describes racial discrimination as intrinsically bad, scientifically false, morally condemnable, socially unjust and dangerous, without justification and repugnant to the ideals of any human society, and these are all quotes from the convention, sex discrimination is none of that. So when you read the CEDAW text, the chief problem with sex discrimination is factual rather than intrinsic. It is an obstacle to women's equal participation in the life of their countries. It hampers the growth of and the prosperity of society and of the family. It decreases women's ability to contribute to their countries and to humanity. I would very much like to hear Professor Raday's and Professor Tirosh's opinion, how they explain this difference. But I'll conclude by saying that this difference can partly explain the acceptance of sex segregation in Israel for economic reasons. And it shows us that we feminists still have a long way to go before we can convince even liberals that women's discrimination and segregation are intrinsically bad and are not merely an obstacle to prosperity. And these 4 wonderful papers that we just heard and this entire conference are certainly a necessary step in this direction. So thank you very much.
Thank you, Gila. I think we do have some time for some questions, and we will also have an opportunity that our speakers would respond to some of Gila's points. Maybe I can kick off this section of questions and maybe second Gila's point to Professor Feldman about whether this is a multicultural accommodation. It's not I do agree, it's not a multicultural accommodation. It's not just like the ultra-Orthodox in Israel have this overwhelming political power, which is really unmatched by any other minority. But nobody is really threatening their identity and their religious practices, which you would find as a dominant rationale for why we want to protect minorities. They're expanding very much. They have a lot of a very established school system, and so it's not the typical minority from the point of view that it's threatening. It's being threatened by the majority to vanish. And I think maybe the case for this segregation in schools among the ultra-Orthodox would have been a stronger claim if it was the ultra-Orthodox wanting to establish a university of their own and wanting to have that university instead of imposing segregation on, you know, the regular universities, the public universities. And this is not a multicultural accommodation. We want to accommodate the Amish, is to leave them alone or for them to have their own institutions. But it's not to impose their own norms and culture on what's happening in Harvard or in the University of Michigan, okay? So it's playing out differently in Israel, which I think is uncharacteristic of multicultural accommodations. And to Yofi, about segregation in Israel, I tend to be hesitant whether it's not applicable in other spheres and on issues concerning not just sex. So if an Arab student wanted to be admitted to a Mamlakhti Dati school, would that be possible? If an ultra-Orthodox wanted to be admitted to an Arab school, would that be possible? We have a lot of segregation de jure and de facto all over. And the question is, once you have that, does that spill over, making sex segregation put in context? It's not just this happening, it's a lot of other things happening as well. I think the claim would have been different if everything, you know, else was inclusive, and when it comes to sex, it happens to be segregation. I don't think this is the true reality of what we have in Israel. But I'll stop here and see what others have to ask the questions. I'm getting it here on the responses.
Yeah, I can raise my question, and thank you to
that's wonderful.
all the presenters.
Please. Yeah,
that's fine. I just wonder to Francis Raday, whether you could say a little bit more about the, let's say, the philosophical resistance to human rights or rejection of the human rights regime as it is promoted by the UN. And I wonder what the impact of that is on your work and our work on women's rights, and I asked whether the ones who are already undermining the human rights are not all too happy to hear not only the political resistors to human rights, but also the philosophical debates. I'm thinking of Samuel Moyn, for example, but many others, and I think Gila actually also alluded to that. So that is my question, and I just wanted to say that I thank you for pointing out that how religious freedom or the ideology of religious freedom by now is being used as the weapon against the human rights efforts and human rights regime. But the first question is my question.
Okay, thank you. We have Elisheva. Would you want to ask the question yourself?
So thank you very much. Everything was very interesting. For Professor Tirosh, if you could, you spoke a lot about sex segregation that we see in Israel from the side of the men. But I was wondering if you could say something about sex segregation from the side of the women, because the case from 2016, I know that you're very familiar with, the students at Hebrew U who asked to be segregated, and they were denied. So I was wondering if you could say something about that.
I don't know if all of the students were denied. It was a number of students that raised the claim of segregation in a party. So, but the student body itself, just to be correct on the fact, was itself very much divided. And the decision, I was dean then. I
think it was a very interesting case, especially because it was the student body was opposed. But the students themselves, there was a group of students who wanted something that it seems to go against everything that we've been discussing in this.
Yeah, but I think eventually it was also the students to decide on this issue. But I'll now refer it back to our speakers, and maybe in a reverse order. And we have some 25 minutes to end this, or a bit less. I guess it's 20 minutes. So Francis, would you wanna go first?
Firstly, of course, I agree with Gila that the contrast between the approach to racial discrimination and discrimination against women it really shows an acceptance by the liberal community. A level of acceptance of discrimination against women, which is not tolerated in terms of racial discrimination. There's no question about that. I actually think that there is a developing gap with LGBTI as well, where I think that it's divided. I think that liberals are more radical in their rejection of discrimination against the LGBTI community and individuals than they are as regards discrimination against women. And that's a whole new topic, but it really was experienced in some ways. Both the resistance to the LGBTI is very strong, and the support for the LGBTI in liberal communities, amongst liberal thinkers is very strong, and stronger than it is in favor of women's equal rights in some ways. And I think that the difference comes as well, both as regards racial discrimination and discrimination against LGBTI, or stereotyping of both communities, different treatment, is because discrimination against women is not only identity, it's also infrastructure. Women perform are placed in the situation of performing free care duties. You require a whole different approach to the economic organization of society in order to give women truly equal opportunity. So I think that's partially the reason for the differences between the three groups. Coming to whether how this debate is seen, there is division. Samuel Moyn is one view. There is the opposite view. Between the two views, there are those who think that the whole of the universal human rights endeavor it is false. It cannot achieve its ends. because of the diversity. And there are those who think that universal human rights is the only way forward. When I was in the UN, and I can't really fully develop it philosophically, but I will say that the secretary, the Commissioner for Human Rights came to us one day, and he was talking about what was going on. And he said the attack, and this I think didn't come out from what Gila, from your critique of what happened at the time of the drafting of CEDAW. He said that the attacks, the backlash against international human rights, the universality of international human rights amongst states is extremely problematic. And he actually gave the example of the United Kingdom, and this was before Brexit. And he said that the most depressing thing that had happened to him during his year as the High Commissioner for Human Rights in the United Nations, the most depressing thing that had happened to him was his visit to the United Kingdom, which of course is an old democracy. And he said that they are abandoning the concept that human rights are universal. Without universality of human rights, women's rights are doomed, because they are the primary victims of a return to traditional values. And of course, I respect multiculturalism, but I respect it as language, custom, culture, not when it violates the human rights of anybody either within or outside the group. So that's the whole point. And there is a deterioration, and I think that is since CEDAW was signed, and maybe it was not radical enough in a way, but it was more radical than anything else up till then. But since then, the backlash is enormous. And incidentally, we brought the Human Rights Council to acknowledge that in a resolution which it passed in 2017, that it's not just that not enough was done, but there is a serious backlash against women's human rights. And the Human Rights Council acknowledged it in 2017.
Okay. Thank you, Francis. Yofi.
Yes, thank you for the questions and comments. I guess I'll start with Professor Gila Stopler's a question which intrigues me, and I'm trying to kind of unpack it. And it was the invitation to think through why. Why is it so much more difficult for us to kind of intuitively recognize the moral repugnancy of sex segregation as we do with race? And one of the reasons I already mentioned in my talk, and it is that it's a convention that is customary in many religious communities, and I would be the last to argue that women who practice it and abide by it or live in some sort of false consciousness or error, and I respect the feelings that there are meanings and positive meanings to sitting in the Ezrat Nashim. I myself enjoyed it as a teenager with my grandmother, this kind of womanly intimacy that the single sex forum enables. And I think there are other reasons. One is that whereas when we think of race, there are hardly any contexts in which race is relevant for anything. Maybe some sort of genetic symptoms or things like that, but or diseases that are prone to people from Ashkenazi origin, etc. But in terms of capacities, abilities, life trajectories, race is irrelevant. And with sex, we don't think that, and we have, for example, a whole industry of research on whether sex differences are nature or nurture, and the female brain versus the male brain, etc. We really want to engage with sex difference and its meaning. Also in our daily life, we routinely segregate. We enter segregated public bathrooms or we conduct segregated sports events. Both issues are highly contested these days and there are major shifts. Biden just introduced some reforms on those issues, and colleges on campuses in the US with bathrooms are a big issue, and still. And maybe the most important reason why sex is different than race in how we think of segregation is that it is nearly impossible for us to think of human beings without referring to them through their sex. So it's kind of the second question we have to ask a pregnant woman after what week are you or how do you feel is, what do you have? You know, is it a boy or a girl? And we don't have the adjectives. Again, this is changing now, and we have the US conventions of, treating people without this binary. And maybe I'll say something that may sound controversial, but I still want to put it on the table. And it ties to the next point of Professor Karayanni. We have high tolerance in Israel to profiling. Unlike the American system, which is suspicious of profiling, let's say in airports, etc., we Israelis in everyday life undergo profiling all the time. When we enter the mall, the guy at the entrance, when we had malls, back when malls were operating, he doesn't really check our bag. He profiles us to see if we're okay. This is just an opportunity to pause and see that I'm, Jewish woman, etc., and I don't pose risk. So these are a few of my answers to this question. And to you, Michael, yes, absolutely. The Israeli society is imbued with distinctions and segregations and profiling. And one of the things we need to take into account, and this ties into Professor Feldman's presentation as well, is that sex segregation, let's say in academia, is also in a non-declared way, a way to segregate sectorially. So to keep the Haredim and the Datim studying alone. So we actually had cases where an Arab Palestinian woman from East Jerusalem wanted to study in the ultra-Orthodox program in Shaarei Tzedek for nurses or something like that. And they did not accept her. They did not admit her because the issue wasn't just her sex. The issue was also her nationality. And the other thing I want to point out is that as much as Israeli society is nationalistic and racist, and we can mention how easily it flies in Israel to say, we're not going to build a coalition with Arab parliament members, etc. It's things that we're accepting as natural. Still, I want to believe that if somebody said, let's have a concert, like in Afula, let's have a concert that Arabs sit here and Jews sit here, or even, let's have a middle area where they can mix if they want to. This is about preference and will and consent. We would not let it fly. The same with segregated academic studies between Jews and Arabs. There's still enough political commitment and moral intuition against segregation based on nationality or on Mizrahi and Ashkenazi distinctions. And to the question, really important question on the example from Jerusalem, I want to say that it's indeed a really good perspective from which to talk about segregation. When women say, we need it, we want to dance behind the divide and dance freely. And I don't have time to give an elaborate answer with an analogous example to ethnicity segregation, and I'll be happy to discuss it with you in person, Elisheva. But I want to say that once we have this divide, make sex meaningful. People are present in this party first and foremost by their sex, and it's noticeable. Whereas in their everyday life as students, we try to neutralize it because we want people to be judged by how they think and their opinions, etc., etc. And the minute you have that, you also have to consider the externalities on not just the secular women, the Orthodox women who are not interested in dancing behind the divide. What kind of peer pressure, what kind of social gaze they will get of what are you religious enough? You claim that you wear a skirt, but why aren't you behind the divide? It becomes a symbolic interpellation of who you are you male or female? Are you religious or not religious? And it's something that is one way to tell the story of enlightenment and I'll finish with that, and of what we've done through the constitutions of the past 300-400 years is that they demanded of us to not notice differences when they are irrelevant. And they should not be relevant. One's color and one's sex should not be relevant in academia as much as it is tempting. And now those women, they were not prevented from being in the party in the section when there are funny skits or whatever, people are on the stage and doing their blessings. If dancing is hard for them, then it's a price that we need to be able to be willing to pay. Because the damage of sex segregation is higher.
All right. Okay. All right. So we have 6 more minutes. John.
Okay.
Go ahead.
So let me respond a slightly different tack, but several of you have mentioned that the Heredim in Israel are probably not good candidates for multicultural accommodation. On the one hand, they're not threatened by any stretch, they're not underrepresented, and they're not powerless. But there's another element here, and that is that whenever you accommodate a culture, as I pointed out, likely the state interfaces with the self-appointed authorities who are typically male. There's a whole section of my research that I didn't talk about having to do with the dynamics of enclaves in transition. And in fact, part of this is a power play by the rabbis to keep at bay internal changes. For instance, the blue shirt Haredim or the 2 women's parties and the Tov party, which challenge from within. So it's not clear that the Rabbanim actually speak in a unified voice for a unified community. So that's one thing that one element we should look at. The second is that if we look at the roots of multicultural accommodation, it actually comes as a reform movement within liberalism. So as Professor Stopler pointed out, part of it is this allergy that liberalism has to interfering in the private realm. But in the early days of the 2nd and 3rd wave feminist movements, the banner they raised was the private is political. They were enjoining the government to take a look at what goes on in the private realm. The other part of that dynamic and the rise of multiculturalism is what we call identity politics. And the Haredim in Israel have learned to adopt the terminology, the language, and the outlook of identity politics. In the same way that white power groups in the United States say, oh, everybody else has this, you're allowed to say I'm Black and I'm proud, and I'm a woman and I'm proud, and I'm gay and I'm proud, but you can't say I'm white, I'm proud. So they actually treat themselves and maybe ought to be seen as a white identity movement that's a backlash to other forms of identity politics. So the fact is that the identity movement started out, I think, as a pretty healthy response to liberalism, which didn't set out to discriminate against anyone. On the contrary, it raised a model, a generic, ascriptive, characterless individual, right? It turns out the character was a white male, but, and we see it in the medical profession, we see it everywhere, that the human that's supposed to be without ascriptive characteristics is actually a male. So the response to liberalism on the part of the Black community, the women's community, was, please don't subsume us in this, kind of generic humanity. And that's both the beauty and the problem of universal human rights. It can eclipse the fact that there are sub-communities that don't fit that generic model and don't get listened to. And so that was the odd, and in some ways beautiful and troubling, rise of multicultural accommodation as a demand was, please recognize our difference. Please recognize our difference. We'll talk about the universal thing later. We'll go back to the 14th Amendment, which again, brand X individual, when we've addressed the differences in our group's access to rights. So it was group terminology, and it was an attempt to challenge and rebut the liberal model, which for all of its beautiful universality did subsume and in some ways suppress the reality of group lives. And we do experience our rights usually in the context of the group that we identify with. And so therefore, all that the Haredim have done, if you will, is to lay claim to, and maybe cynically and falsely, but lay claim to, we're a subcategory. All right, we're not immediately threatened, we're not underrepresented, but we are so authentic. We are the authentic Jews, and we want to not only maintain our insularity, but to have all the benefits that participation in Israeli society provides.
Okay.
So it's a conundrum. It is.
Okay, all right. Okay, fine. Last but not least, Lisa, please.
Okay. Well, I guess I'll just respond to Gila's question, which was, are the courts more likely to accept the claims of Hasidic communities and Hasidic parents that they really can't adapt and respond to change? Yeah, they are. But there are opportunities to push back. Often the arguments are rooted in the possibility that children will be subject to bullying. And it's made to seem as if this is an organic revulsion that flows naturally from the community, when often it is an organized and strategic response, and the bullying isn't necessarily just coming from there. It's also coming from choices made by leaders in the community to exclude children from the schools. And we see that in English cases as well in the matter of M. The only thing, a hopeful thing I can point to is a series of arguments that are being made by Footsteps, the legal team that does pro bono work on behalf of these parents, that tries to draw an analogy between complicity in persecuting Exeter parents and complicity with persecuting and discriminating against gay and lesbian parents, or being complicit with racist parents, which the courts have turned their backs on in recent years. It used to be that if a spouse left and engaged in a gay and lesbian lifestyle, that would be a justification for denying them custody, but the courts are no longer willing to be complicit in that. And court, all the way up to the Supreme Court in Palmore versus Sidoti, the court determined that a claim by a white parent that the other parent's custody should be cut off because she had married a Black man and the child would be subjected to bullying and discrimination there. The court said that may all be true, but it's not our role to put our imprimatur on discrimination that happens within these communities. It's our role to push back. And I find that a helpful and inspiring model of what might come in the future.
Well, thank you. That was all very fascinating. And this is a topic, obviously, that fits very much in an Arabic quiz that we sort out with our kids, telling them, figure out what is the thing that you take more from, and it only gets bigger. And I guess this is a topic that the more we touch upon it, it only becomes much bigger and much more interesting. At least that was my experience with researching religion and state, at least in Israel. I want to thank you all for the fascinating papers, presentations, and the discussion.